Dear participant, welcome to MOOCs. I am Palab Pradhan, working as Scientist B Library Science at Information and Library Network Center, Gandhinagar. This is module called as Intellectual Property Rights and Copyright Issues under the paper Digital Libraries. You have already learned a lot on various aspects of digital libraries in the previous modules of this paper. In this module, I'll be talking mostly on intellectual property rights and copyright in digital libraries, which will include contents like what is IPR, what is copyright, then what are the copyright issues and how to manage those issues before and after while planning or developing any digital library or digital collections. At the end of this module, I'll be touching upon the Indian Copyright Act and the different international copyright treaties and their status in brief. As we know about the fact that the information and communication technology has changed the way we used to transit, access and retrieve information from resources available in libraries. Earlier, physical books were available in libraries, which were considered as the basic sources of information, but today libraries are more focused on building digital collections of electronic resources and digital materials, which are called as digital libraries. According to NISHO 2007 framework, the digital collections consist of digital objects that are selected and organized to facilitate their access and uses. And good digital collections include metadata used to describe and manage them, including copyright clear. Here, digital objects include still images like photographs, then textual documents like books, journals, and theses, then moving images like videos and audio, then statistical raw data files. So, digital objects are generally of two types. One is on born digital, which means the document which is generated in digital form at the time of its creation, and the second one is converted from print to digital. However, it's not the same as physical books while developing digital collections in a digital library. Developing digital collections needs clearance of intellectual property rights, specifically copyrights from the respective authors or the owners of the rights. So, in the entire process of planning or developing a digital library or its collection, it is very necessary to obtain copyright clearance for each and every document being digitized or collected, without which developing digital collections or digital library cannot be achieved. So before going into details on intellectual property rights, first we should know about what is intellectual property rights. Then according to World Intellectual Property Organization, that's called WIPO, intellectual property refers to creation of the minds, such as invention, literary or artistic works, and symbols, names, images, and designs used in commerce. Then, what is intellectual property rights? It refers to the protection of creation of the minds, which are both a moral or any commercial value. IPR typically grants the author of an intellectual creation exclusive rights for exploiting and benefiting from their creation. So, intellectual property rights are in different form. Some of them are outlined, as you can see your computer screen. So first is trademarks, including service mark. Trademark is a sign that individualizes the goods or services of a given enterprise and distinguishes them for those of competitors. Under the IPR protection law, a trademark must be distinctive in nature, not deceptive or illegal or immoral than geographical indication. It is basically a notice stating that a given product originates in a given geographical area. That indicates the geographical area. Industrial designs. It is the aesthetics and ergonomics of a product. It consists of three-dimensional elements such as the creation of the product shape, then two-dimensional ones such as graphics, its patterns and its colors. Then patent. Patent is an exclusive right granted by law to an inventor or assignee to prevent others from commercially benefiting from his or her patented invention without permission for a limited period of time in exchange for detailed public disclosure of patented invention. Then a layout design of integrated circuits. It refers to a product in its final form or intermediate form in which the elements, or at least one of which an active element, and whereby the interconnections are integrally formed in an and or a piece of materials which is intended to perform an electronic functions. Undisclosed information including trade secret. Trade secret basically means that any information of commercially value concerning products or sales operation which is not generally known, the owner of trade secret must take reasonable measures to maintain its confidentiality and secrecy. Then control of anti-competitive practices in contractual licenses. Then the last one is the related rights. It means that related rights or the neighboring rights, so it's called, the rights that in certain aspect resemble copyrights. The purpose of related rights is to protect the legal interest of certain individuals, namely performers, producers, or any broadcasters, and to help them deliver their message to the public. Based on their specific nature, intellectual property is often divided into two categories. Firstly, industrial property, which includes patent, such as invention, then trademark, that we already told. Then the other one is the copyright, which includes literary and artistic works such as novels, poems and plays, films, musical works, and so on. Then what is copyright? The copyright is a right given by the law to the creators of any literary, dramatic, musical, or any artistic work and producers of cinematograph, films, and sound recordings. Copyrights includes a broad range of rights. The first and foremost, the reproduction right. It is the right to make copies. For the purpose of the reproduction right, a copy of a work in any form in which the work is fixed and from which it can be perceived, reproduced, or communicated, either directly or with the aid of a machine. Then the right to create adaptations or derivative works. A derivative work is a work that is based on a copyrighted work but contains new materials that is original in the copyright sense. For example, you can say that Windows 2000 is a derivative work based on Windows 98. And then the right to distribute copies of the work to the public. The distribution right is limited by the first sale doctrine, which provides that the owner of a particular copy of a copyrighted work may sell or transfer that copy. It means that the copyright owner, after the first sale of a copy, cannot control the subsequent disposition of the copy. Anybody can publish it and sell it. The right to perform the work publicly. It means to perform a work means to recite, render, play, or dance, or act it with or without the aid of a machine. For example, we can say that performance in a musical live concert or playing of a CD on which the any video songs, compositions, audio files is recorded. Then the right to display the work publicly. It means to perform or display it any way that is open to the public, or any way that a substantial number of persons outside of a normal circle of a family and its social acquaintances is gathered. Making a work available to be received or viewed by the public over an electronic network is a public performance or the display of the work. However, the copyright law distinguishes between ownership of a copy of a work and the ownership of the copyrights. Both are the different things. In context of a library that acquires a book doesn't thereby automatically acquire the right to reproduce it. It can just have it in their library. It just own only the physical copy and not just the copyright rights associated with that physical book. So it is very important to manage the copyright issues to have a digital collection. So we'll discuss now the how to manage copyright issues in digital library. So as I said, it is very important for the library professionals to understand and adhere to copyright issues involved in developing digital collections. Any document which is added as a part of digital collections and access is provided for wider use over the internet has to have copyright clear, or one has to ensure that it doesn't violate any copyrights of the author or the owner of the rights. So what are the specific issues or ways we can manage the copyrights related issues? So we'll discuss it subsequently. The first and foremost is the fair use. If any resources to be added, then that have provision stating that it is being used for non-commercial activities such as research, private or individual study, academic purpose, writing reviews and criticism. That document should not be used for any commercial benefits. That should be solely used for any personal work, research like that. Then documents in public domain. The documents available in the public domains as a policy for wider use, one can safely add this to their digital collections because that is already available in public domain, so that can be added to their digital library collections. Then written agreements and permissions. In this matter, one has to seek the written agreement with certain clear permissions, their terms and conditions from the authors or any publishers or the specified copyright holders for adding that document to their digital library collections. Then licensed resources. There are certain documents where copyright holders have clearly stated what can be done and what cannot with such documents. Depending on their stated policy or licenses, any libraries can consider to add those kind of documents into their digital library. Then Creative Commons. Presently, with the help of available digital technologies, a number of documents are generated in electronic format on a day-to-day, time-to-time basis. Those are generated by individuals, institutions, then associations, many funding agencies, government departments, and many more. Considering either as policy mandate or other factors which favors authors and users, these documents are made available under different Creative Commons licenses. Depending on these licenses, you may decide to include those documents in their digital library collections. Mostly, all of us, these licenses encourage wider usage with due acknowledgement or credits to the author or the copyright holders. So, while discussing about copyright, how to manage copyright issues in libraries, digital libraries, the Chinese scientist Dmca has discussed and raised specific issues on IPR specifically in digital context on Chinese copyright protection system. That can also be applied, that can also be relevant in Indian context. So some of this you can see in your computer screen. That is digitization to be considered as similar to reproduction, for example using a Xerox machine. Then is digitization a deductive activity such as translation from one language to another? Then can transmission of digitized document through internet we consider as commercial distributions or public communication similar to broadcasting? Is the principle of exhaustion of the distribution rights still effective in the digital age? Then he further said that can we consider a database as a special collected work that should be protected by the copyright law, or it can be considered as a special work requiring specific legislation for its protection. Further, he said that what can be considered as fair use in the internet environment, because now everything is open in internet. Those are having internet access can access anything available over the internet. So further he said what are the concerns of the library community that we need to consider. Then in the digital consensus, further, if access could be technologically restricted by the copyright owner, how could the public exercise fair use with regard to those work? Then further, libraries should be prevented from employing digital technology to preserve work by making 3 copies, an archival copy, a master copy, and a use copy. that can be possible or that cannot be possible, that we need to consider. Then again, whether internet service providers, including libraries or any educational institutions, should be liable for copyright infringement merely because they facilitated the transmission of digital data that translated into another party copyrighted work. Apart from all these mentioned issues, there are few other such instances or issues where libraries are having difficulties in context of copyright, so that is subsequently be described. The libraries as a service-oriented organization provide Xerox facilities for specific individual research and education purpose. They do photocopies of articles or digitized documents to provide ILL service. So digitization is considered as reproduction of the initial work into digital form, and the process of changing is accomplished by a machine without any creativity. It can be considered as a change from print to digital, and as such, there is no creativity involved in digitization, and the copyright protects creative works only. Currently, libraries are dealing with many e-books, e-journals, publishers and vendors. They are negotiating and signing contracts, agreements to get access to e-resources by paying subscription fees for a specified period of time, maybe 1 year, 2 years, and so on. In these cases, copyrights are moreover now being replaced by contracts and agreements in between libraries and the publishers. There, libraries could ask a rights holder for permission to copy those subscribed e-resources for preservation purposes or for perpetual access to those resources, as they have already paid for that specified limited period. So, model licenses again that it could reduce the burden on libraries and publishers, where the publishers undertakes to provide access to the archive of subscribed materials once a subscription ends. That's source in perpetual access also that I told you before. Then we'll talk about the Indian Copyright Act. What is its status now? That Indian Copyright Act 1957 came into effect in independent India from January 1958 onwards. Basically, it has its origin, it has its roots from Indian Copyright Act 1847 enacted during the period of during the period of East Indian Company. The Copyright Act 1957 has been extensively borrowed from the Copyright Act of UK, United Kingdom of 1956. Further, this act has been amended 5 times respectively on the year 1983, 84, 1992 and 94, 99. The Copyright Act 1957 continues with the common law traditions. The 1999 amendments have the Indian Copyright Act fully compatible with the international trade related aspect of intellectual property rights, so that is called as TRIPS copyright agreement. Also, India is signatory to both the Bonn Convention of 1986 and Universal Copyright Convention of 1952. To look after the copyright issues and its proper implementation, the MHRD, Government of India, has constituted a Copyright Enforcement Advisory Council. Now we'll talk about the international copyright treaties and their status. There have been a lot of international treaties over the years around the world that have been signed by a number of countries, and the World Intellectual Property Organization, WIPO, which is special agency of under the umbrella of United Nations, each responsible for all these treaties, making it a success and administering. So far, WIPO has administered 23 international treaties that cover the various aspects of intellectual property protection. And currently, WIPO have 188 signatory member states all over the world. Here again, I'll talk about a few of the important international conventions and treaties related to copyright protection. The first and foremost one is the Bonn Convention. Berne Convention for the Protection of Literary and Artistic Works, that is broadly and popularly known as Berne Convention, is an international agreement governing copyright, which was first accepted in Bern, Switzerland in 1886. As of May 2016, there are 171 states that are parties to the Berne Convention, which includes 170 UN member states plus the Holy See country. Berne Convention's agreement assists the nationals of its member states with international protection for such works as novels, poems, plays, songs, musicals, then paintings and architectural work. Then Universal Copyright Convention, that is the UCC, which is adopted in Geneva, Switzerland in the year 1952. It was developed by United Nations Educational, Scientific and Cultural Organization, UNESCO, as an alternative to the Berne Convention for those states which disagreed with aspect of the Berne Convention but still wish to participate in some form of multilateral copyright protection. These states included developing countries as well as the United States and most of Latin America. Under this, each member state undertakes to provide for the adequate, effective protection of the rights of authors and other copyright proprietors in literacy, scientific and artistic works, including writings, musical, dramatic and film works, painting, then sculpture. Then further, the Rome Convention happened. The Rome Convention is for the protection of performers, producers of phonograms and broadcasting organizations. It was accepted by the members of BRP. It is producers of the modern world intellectual property organizations on 26 October 1961. The agreement further extended copyright protection for the first time from the author of a work to the creator and owner of the particular physical manifestation of intellectual property, such as audio cassettes or DVD. Then it comes Geneva Phonogram Conventions. It is called as the Convention for the Protection of Producers of Phonogram against unauthorized duplication of their phonograms. It's shortly called as the Geneva Phonogram Conventions, which was passed in the year 1971. It is related to copyright protection for sound recording specifically. Then the TRIPS Agreement. It is the agreement on trade-related aspects of intellectual property rights. It is an international agreement administered in 1995 by the World Trade Organization (WTO) that sets down minimum standards for many forms of intellectual property regulations as applied to the nationals of other WTO members. The TRIPS agreement introduced intellectual property law into the international trading system for the first time and remains the most comprehensive international agreement on intellectual property to date. Specifically, TRIPS requires WTO members to provide copyrights right covering content producers including performers, the producers of sound recordings and broadcasting organizations, their geographical indications including appellation of origins, terrestrial designs, integrated circuit layout designs, patent, new plant varieties. It covers almost all things. Like further, it covers trademarks, trade race, and undisclosed or confidential information. Further, TRIPS also specifies the enforcement procedures, its remedies, and dispute resolution procedures whenever it occurs. Then, WIPO Copyright Treaty. In the year 1996, the WIPO Copyright Treaty was negotiated under the auspices of the World Intellectual Property Organization (WIPO) to address issues raised by new technologies, which is we called ICT or digital technologies. Under this treaty, the signatory countries has to provide legal protection to technologies, technological protection measures, which is called TPMS, which can be used by right holders to control access to and use of digital copyrighted works. Further, the first and foremost and is very important, which is called the Digital Millennium Copyright Act, DMCA. The DMCA Act is a United States copyright law that was passed on October 12, 1998. It criminalizes production and dissemination of technology, devices, or services intended to circumvent measures, which is commonly known as digital rights management or DRM, that control access to copyrighted works. It also criminalizes the act of circumventing in access control, whether or not there is an actual infringement of copyright itself. In addition to that, the DMCA heightens the penalties for copyright infringement on the internet also. The DMCA amended Title number 17 of the US Code to extend the reach of copyright while limiting the liability of the providers of online services for copyright infringement by its user. Here, to conclude, I would say that digital materials which consist the digital library collections covered by some copyright, maybe by an author, publisher, or anyone else. So it is for the library professionals like us to ensure that these rights should not be violated while creating digital collections in digital libraries. We should properly understand the various available provisions to manage copyright issues effectively in our libraries as well as in our institutions, and also we should make aware our academic and research community for the effective management of copyright issues to excel in research.